So welcome, everyone. We are here for a workshop tonight, and welcome to Lewiston, the second largest city in Maine, but the city with the biggest heart. If you will rise and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. So thank you. I just want to mention two things. One, I've received several requests for public comment tonight, so I just wanted to let folks know that we will allow public comment on each of the items on the agenda. And also wanted to congratulate Councilor Ray for being nominated as the school committee representative to the Regional Service Center. So we will start with a work session on the Tree Street banners.
Good evening, Mayor and City Councilors. Tonight we have Matt Shaw from Community Credit Union here to provide you with an update or a proposal that would involve placing banners along Pine Street around the Tree Street neighborhood. Back in May, I did meet with Betsy Sibley from Community Credit Union and her team, where they initially proposed the idea of placing banners up along Pine Street, like I mentioned. So we discussed the overall process, which would require a city council approval of the content of the banners, as well as approval from CMP, because that's where they intend to put the brackets and place the banners on their poles. So we are still waiting for approval from CMP at this point, but we thought it was appropriate to bring forward the design since they've completed it and talk through about what their proposal is. And once we get approval from CMP, we'll bring all this back for an official approval and vote to the City Council. At this point, I'll turn it over to Matt and let him cover the proposal.
Thank you, Dennis. So again, Matt, I'm a resident of 2 East Merrill Road in Lewiston, Maine, here representing Community Credit Union. So what first came about was Community Credit Union has partnerships with Healthy Neighborhoods and the Choice Neighborhood Grants, where we're trying to beautify downtown Lewiston, as well as the Pine Street neighborhood and the Tree Street. So we came about and applied for a grant for banners that would welcome them, similar to those of the downtown Lewiston, and kind of mimicking that design throughout other areas of Lewiston, especially Pine Street. So in your packet, you did receive a picture of a banner mock-up. How we came to about this, our Pine Street office is located directly in the heart of Pine Street, and we invited the Healthy Neighborhoods individuals, as well as our membership and the surrounding community, to come in and vote through our lobby, as well as speak with those individuals from Healthy Neighborhoods. And we also put it out through voting on the lovely social media channels of Facebook, in which we got a lot of comments of great accolades and pride for Lewiston, especially the Tree Street area. So it did reach over 1,000 impressions through social media and had just over 250 votes, in which that's where we came to our final decision on the design that we're presenting for you tonight. So the banners will resemble what is being placed on Lisbon Street, and that is our goal, so that there's symmetry throughout the entire city for where we're working. So I would open it up to questions from you guys at that point.
Questions on the council? Councilor
So is there a standard size for our banners? Is that what you're saying, that you're going to be putting them on the mountings that are already existing and stuff like that?
That's where the project work with CMP comes along. They will give us the definition of what we are allowed to have on the pole, and then we will work to have them be a standard size across. So if there's a taller or shorter version, we will most likely go with the shortest version so that all the banners are similar throughout Pine Street. And like we are using currently, our goal is to use a local vendor or a vendor that will provide the same amount of quality work, so that things are kind of symmetrical across the city as well.
Other questions on the council? Councilor Ray.
Does the grant cover installation and taking down of the banners on a yearly basis, or can they stay up year-round?
The grant that we currently have applied for, we are looking for it to cover completely the installation. There will be no cost on behalf of the city, as well as the banners that are placed. And the design currently is one that could be year-round. We might look for future grants later on through the Choice Neighborhoods grants to be able to change them out or replace or those kinds of things. But we are looking to the grant directly, nothing from the city for any funding.
Great. They look great, so thank you.
Thank you.
So I would just add that I really love the design, and I think it'll be a great addition to the neighborhood.
The design that we came from resembles the logos of healthy neighborhoods. So we're again trying to immerse that logo as well in different parts of the city. So that's kind of where the design, the leaves, and that kind of stuff came from. So
Great. Thank you.
thank you.
We will now move on to a discussion of no smoking in city parks.
Yes, as you'll recall, at the last discussion of this item, which originally came forward as limiting tobacco use in just one location, the council suggested we expand it from that to all of our city parks. So I've made that change, and at that discussion, it was a question about fines. And in our current ordinances in section 54-11, there is an existing fine for violation of what was the no smoking in certain locations ordinance. What I would suggest, number one, is that we take that section on penalties out of the ordinances and put it in with our miscellaneous fines and penalties policy, so it's in one place. And second, I would recommend that we match the fines for violation here with the fines that we set up for violating the no smoking in the hospital zone ordinance that we just did recently, which is $100 for the first offense, $200 for second, and $300 for third. Since that was not discussed at the last session, I really wanted to come back with this to make sure that that was acceptable to the council.
Questions from the council? Councilor Ray?
So since starting this conversation, things have snowballed a little bit for me in receiving some constituent feedback. I was reached out to and asked if there was a possibility of extending this ordinance to the business frontage on Lower Lisbon, kind of our downtown business area, with a number of business owners kind of signaling their support for a move in that direction. As we're having this conversation, it seems a little out of step to, well, maybe it isn't, to work on this and then come back to that later. So I just wanted to make that a part of the discussion now. And folks who have signed on to that idea are the owners of Heirloom Arrangements, The Vault, Rainbow Bikes, Boba, J. Dosty Jewelers, Rink, Doobie's Flower Shop, as well as the owner of 120, 215, and 277 Lisbon Street. There is some work being done by Healthy Androscoggin on research for this sort of ordinance, kind of based on what Brunswick just adopted, but I just wanted to make the whole council aware of that for part of the discussion, perhaps.
Councilor Lyson?
Yep. What part of Lisbon Street are they talking about?
It's
From
the
Ash
lower.
from Ash to Maine?
I'm not entirely certain. It might be from Pine to Maine.
Okay. Thank you.
So I don't know if either one of you knows what our current, what the current frontage is that you can smoke on the, how far in front of businesses you're able to smoke right
The
now?
only restriction we have on smoking in the public right-of-way is the restriction associated with St. Mary's Hospital.
Okay.
So right now, there are no other restrictions except St. Mary's Hospital and then the specified parks that we're looking at expanding to cover our entire parks system.
So, does it make sense to talk about these two things together, or does it make sense for us to, the ordinances would need to be separate, probably.
Yes, because that would go into a different section of the ordinance. And we are so far along with this, we might as well just get this done. I think other issue is a bigger issue, and I know at the same time, we also have had some communications from Central Maine Medical Center asking us to look at something similar for them to what we did for St. Mary's.
Okay. So could we maybe make this a workshop item?
I would think that we would want to do that, and obviously, we'd need a little more clarity on the specific locations that people were talking about so that we know what was being discussed. But I think a workshop would be a good idea to get the folks who are interested in it in, gets the word out, because there may be opposition to that you would like to hear from.
So, maybe Councilor Ray, you could work with Healthy Underscog.
Absolutely.
Okay. So, back to parks. Sorry.
So if everybody's okay with what's been proposed, that's what we'll have on the agenda for first reading.
In terms of the parks?
Yes.
Yes. Councilor Marcotte?
That would be next week.
Yes.
And there may be someone here in the audience tonight which was the impetus to my requesting that this move forward. They would like to speak.
Sure.
Good evening. My name is David Dubord. I live at 95 Cumberland Avenue. And in Lewiston, I also co-own a building at 86 Lisbon Street in Lewiston. We employ 10 people. I originally approached Councilor Marcotte about the idea of no smoking in Dufresne Plaza. I understand from your last meeting there was interest in expanding that, and I'm certainly in favor of that as well. Dufresne Plaza in particular is quite a thorough way for people coming from the parking area to the courts, to downtown to eat, to many places. And it has become a smoking hangout in some respects. It's difficult to get through the plaza on any given day without going through secondhand smoke or coming near secondhand smoke. And so it's unhealthy, it's uninviting, and it's unattractive. I did bring a photo of just one small section with all the cigarette butts strewn out, everywhere, and that's representative of the whole plaza. I don't think we're putting our best foot forward as a city when, this area that was to honor one of our respected jurists and is, again, a gateway to the downtown, is constantly filled with smoke. But I would support the broader ban of no smoking on all city-owned properties, because I think all of us are entitled to enjoy it, and when you have smoking, that limits the access that people have to the area. So I would support the broader ban.
Thank you. Any questions? Great, thank you.
Thank you.
Any further discussion on this item on the council? All right, so I think we're good for next week.
All set?
Thank you.
And number 3, we will move on to nursery schools in residential zones.
All right, we're moving along. This is good. All
Don't say it out loud, Dave.
right. Any questions? Good. All right. So you folks remember that you acted on an amendment to allow nursery schools as a separate defined use. Along with that were specific performance standards that were in the definition of nursery schools that referenced what could occur in the NCA district. That is in your packet, it has the language in there that was currently approved, and there's also new language in there at the request of the council. When you made that amendment to include nursery schools, allow them on properties in the NCA with 1 acre or more, you said, hey, why don't we look at the other districts, the other less dense districts, and if we're allowing it in the NCA, why aren't we allowing it in these other districts as well? So staff worked on an amendment. We brought that to the to the planning board. They voted unanimously on it, and we're here to talk about it tonight before we schedule for a public hearing. So if you look at the actual amendment, this page here, the one that has the strikeouts and underlines, and actually I say that it's just all underlines. We've added low-density residential, suburban residential, medium residential to districts where you can have a nursery school that's limited to no more than 12 children, and that has to have at least 1 acre of land, and it has to be accessory to a single-family home. And the whole reason we got there is because the council said, hey, if that's good for the NCA, maybe it's good for other zoning districts as well. The other thing I'll point out, when you look at the tiny space and bulk, the land use chart, super tiny, there was a number 22 that's been crossed out. If you look under nursery schools, and I know you can't see what I'm doing right now, but nursery schools is up here, and you'll see across here, there's a bunch of C's and a P's and everything like that. And where you see the 22 crossed out, that was because originally in those zoning districts, low density, suburban residential, if you wanted to have a nursery school, it had to be accessory to a church, a school, a religious facility, something like that. Again, The thought was at the last meeting, if you're allowing it in the NCA as a standalone use, then why aren't you allowing it in those other zoning districts as a standalone use? And when I say standalone, again, it's accessory to a single-family home. It's not as though you have a nursery school on a individual lot in a residential district. It would be accessory to a single-family home. So you did what you folks asked, the planning board acted upon it, and we're here to see if you have any questions or
The
comments.
planning board, you might go over the planning board's vote, it wasn't unanimous.
It wasn't even fast.
It was 3 in favor, 2 against.
Oh, I'm sorry, you're right, that's a great point. Yeah, that's absolutely, yeah, exactly, thank you. And because of that, even though appears to be favorable, it's not a quorum, so the vote didn't necessarily pass. So for you folks to act on that, to actually pass that, you would need a supermajority. Thank you, Ed, I forgot about that.
Did the planning board actually, procedurally, they held the public hearing and
They did.
everything was required?
Yep.
Okay, I wasn't sure on that part. Thank you.
So when the planning board forwards a recommendation to you folks on anything that's related to zoning and land use code as far as an amendment, public hearings with them, a quorum is at least 4 people, and you have to have at least 4 affirmative votes for it to be a positive recommendation. It was a 3-2 vote. So while it looks like it passed, it didn't. You guys can overturn that via the zoning and land use code with a supermajority vote, which would be at least 5 of you.
Counselor Lyson?
Thank you. There wasn't much of an explanation of why, I mean, there were only 5 people at the meeting, right? So there were 2 people missing? 'Cause that's-
Correct, yeah. And now we actually have a full board now. Since then, the mayor's made some additional appointments, so we had a full board for the first time in some time.
So I don't know if we want to remand that back to them or not.
Yeah, so that was my question. Is there opportunity for us to send it back to them to have or is that not a?
And if I could,
I mean, to
there's
vote
no
on something we
explanation
don't
of why
have
they
quorum
were
for.
against the amendment, because it seems to make, common sense. And there's nothing in the memo, and I'm just wondering if you could you explain, if you were there, what was the 2 people who voted against its objection to the?
Yeah, it wasn't necessarily that clear. I mean, there's some explanation here. We had some people that spoke against it again, similar to the council meetings, is talking about how you may be further impacting the residential neighborhoods, introducing more traffic, more noise, that type of thing. So I'm thinking that was part of the reason why those planning board members voted against it. To your point, we typically try to get more direction from the planning board when they vote in opposition, certainly when it's a majority, so I can share that with you folks. But in this case, there wasn't any specifics provided. I would say with going back, and this may be either Ed or Kathy Monteo question as far as, parliamentary procedures and whatnot. I mean, typically to reconsider something, there's a whole process to doing that, and it should have happened at the next meeting and whatnot. It would have to be people voting who voted in favor. I would think that would apply here as well.
I mean, I guess I made the suggestion, but I don't think it's necessary for that to happen for us to go forward. I think we can, too. Obviously, we need 5 votes, so there has to be pretty good consensus along in the council.
Counselor?
I'm just still pretty confused about this second page of the memo. The date was September 17th in the future? No, or was this for the
That's when the
August-
memo was generated. That's the date of the
What
memo.
day is today? September 10th, right?
Today's
Yeah.
September.
So this is from
What's
August
today's
12th?
date, David?
That's a good question. I don't know. Doug is ahead of himself here.
So this all happened on August 12th?
That's correct.
Okay, I'm sorry, I could not keep up with that. Thank you.
Well, the memo probably wasn't sent on August 12th, but the date of the planning board meeting was on.
That's correct. The action of the planning board was on the 12th.
If he's using Word and using autofill for date, every time you bring the document back up and relook at it, it updates the date. That's probably what happened.
Good catch.
Not yet, I couldn't get my head around that.
Other questions on the council?
So our plan is to bring this back to the council for first reading.
Is there anyone in the public who wants to speak to this item?
Hi, good evening. My name is MJ Langley. I live at 411 Pond Road in Lewiston. I strongly feel that residential neighborhoods should stay residential. Nursery schools are for-profit. I know that there are many other nursery schools located inside schools or churches that are for nonprofit, as well as the other nursery schools. They are all located, that are for-profit, are all located in commercial areas around the city of Lewiston. I feel that opening this door to pass this will only snowball. It will give the opportunity for other people to open home-based businesses in their homes. When you look at preschools, the only thing that's regulated on preschool is the sessions, how long they are, 3.5 hours. You could gear a preschool to anything. It could be like a trade school. It could be if you wanted to gear something towards cooking or, sewing or whatever it is. You could have a nature school. It could be whatever it is. It could be at whatever times you choose of the day to do your school. It could be 1 hour. It could be 3.5 hours of 2 sessions. So doing this will definitely be a turnoff to the neighborhoods, bringing these businesses into your neighborhoods. Neighborhoods are for living. I know that's why I chose my neighborhood. Businesses and commercial activity, they belong in an alternative zone, not in your neighborhood. Once you bring your businesses in, that becomes an industry, whether it's heavy, light, or medium. That's what it is. So passing this would definitely increase the motor vehicles, and which also could increase the pedestrian injuries and, of course, the noise level as well in your neighborhoods. So I appreciate you took some time to think about this and keep our residential neighborhoods residential. Thank you, guys.
Thank you. Would anyone else like to speak to this item? Questions, further comments on the council? Councilor Wright.
I'm just catching up to all of Dave's presentation now. I'm so sorry. You said, or maybe Ed said this, it would need a supermajority to pass the council?
Correct, it
at
would
this-
need 5 votes from the council to pass.
And this is coming on Tuesday?
That would be my plan unless I hear differently.
I will not be here,
Oh.
as I indicated via email, so if that changes anything for anyone.
We might want to wait till we have a full council. That would be my suggestion at this point, because at that point, you're looking for 5 of 6.
Councilor Lyson.
Yes, David, now, currently, this is allowed in the NCA,
Correct.
right?
As a-
So,
remember-
and
remember
if this
it's con-
doesn't pass, it will still be allowed in the NCA.
Right, the
Yes.
NCA's been approved, you have to have an acre, you're
So,
limited to
I
12
mean,
kids.
that's, and again, I think part of what we're thinking is the NCA, I don't know what the proper word is one of the more protected residential zones in the city, always has been, from the get-go. Not that I agreed that all those areas that were NCA should have been, but we've had that discussion as well. But it was really a protected one. So it's not going to solve the situation focusing on the one nursery school that's been proposed right in an NCA, correct?
Correct, this
That
has
will
nothing to do
not
with
affect
that.
that one
That
at all.
amendment has been approved by the council.
So, the logic was, if we allowed it in one of our most protected, why wouldn't we allow it? Shouldn't we put conditions on those other 3 zones, basically, right?
Correct, because you would have been able to do with them in those other zones, but it had to be accessory to a church, a school, things of that nature. Well, if you can do it, why are we saying it has to be accessory to those uses? If you can allow it in a single family and have the same protections, it's only 12 kids, it has to be on at least an acre of land. Those other zoning districts have bigger minimum lot sizes than the NCA to begin with. But the concerns, that you heard here, those are some of the same concerns that were brought up at the planning board. That's why you had a split vote.
Okay, thank you.
And just one other reminder that in all of these residential zones, it would be a conditional use.
That's correct.
So it's not a use by right. It would have to go through the Board of Appeals to have someone take a look at, or the planning board to have somebody take a look at the.
Yeah, either one of
conditions.
those, we would make a decision upon the application, but it's a Board of Appeals or the Planning Board that grants conditional use permits. So that was part of the argument for the controversial one that you folks were having, even though it wasn't project-specific, is that neighbors would be notified. If somebody wants to do this in their backyard, the neighbors would be notified of it. The Planning Board or the Board of Appeals would have an opportunity to look at hours of operation, traffic, things like that, and how could the applicant potentially mitigate those.
Go ahead, Jolie.
No, go ahead.
All right. The other thing is that I think that concerns were raised that there wasn't public notice to the amendments of the code, and typically we don't do that unless it's project-based or whatever, right?
That's right, yeah, there was confusion with that, and I think we straightened that out. I don't know whether it was appreciated, but yeah, when we do a large zoning amendment, unless it is project-specific to a specific property, the notice is a legal ad in the paper. I mean, that's the notification. We've since made some changes in-house because some folks were saying, well, geez, I don't go to the clerk's office, I don't read the Sun Journal, so we're trying to remind ourselves now whenever we have something going to the Planning Board, Board of Appeals, we're putting it on the city's Facebook page too, just as another means of outreach in case people are interested.
Thank you, David.
Counselor Bean.
I think there's a real problem with the fact that we made it a conditional use, but I don't see it here. If it is written down somewhere, please correct me, but I think it would be important to make what the conditions the Planning Board and the Appeals Board would be looking at as part of the definition, because the definitions are just the size of the building, the size of the acreage, but it doesn't really address some of the other issues on paper.
So what I can offer you, other than on that tiny chart and where you see a bunch of Cs meaning conditional, you're right, that's all you're going to know right now. That means it's conditional. But conditional uses are regulated under Article 10, and so the things that the board, either the Planning Board or the Board of Appeals, are going to have to look at is whether the proposed site is such of a character, whether there will be an adverse impact on the quiet possession or value of surrounding properties that would be greater than what normally would occur. This includes whether the size of the proposed use is comparable to surrounding uses, the amount and type of traffic to be generated, hours of operation, pavement, number of parking spaces is comparable to surrounding uses, generation of noise, dust, odor, vibration, glare, smoke, litter, and other nuisances is comparable. The impact on the impact on the quality and quantity of groundwater is comparable, and whether or not they're basically doing a bunch of site work to the property, altering the terrain and topography out there. So, I mean, a lot of these aren't going to be an issue probably as far as groundwater, site work, but certainly someone's going to have to come and say, how is this comparable to a surrounding use? I would say the argument would be, well, if you allow family daycares with 12 kids, they're probably going to say, why not allow a nursery with 12 kids? That was how this whole discussion started. Traffic, that's something that each applicant's going to have to speak to as far as the amount of traffic being generated, the type of hours, the expanse of pavement, what are they going to need for parking, and how are they going to generate, how are they going to speak to issues like noise? We heard concerns about noise from, children outside and play activities. Is that something that a neighbor may have to address with fencing or a buffer or something like that? But those are the criteria that whoever the appropriate reviewing authority is, they're going to have to address those.
And it's not written in the definition of the ordinance.
It's not in the definition, but it's in the ordinance itself.
Okay. When we discuss this and we vote on it, I really would like to have a discussion of the things that Appeals Board and the Planning Board need to look at, And also, if we could all have our own lists, or the language that you just read, because I think it's pretty vague, and a lot of people aren't aware exactly of all the things that have to be met before this conditional use will be accepted. We can't do it for the one, the NCA district that we've already voted on, as far as the language is concerned, but perhaps it'll filter through. I don't, and perhaps if we had a way of knowing that all of those things were addressed and what the consensus was on paper before we vote, it would be nice to know that all of these things were considered. And of course, that's not going to happen until we vote to change the definition. I understand that, and so it's only going to happen if somebody decides to have a nursery.
That's correct. And you folks wouldn't,
And at that time, I really would like us to, I don't know how I can get that to happen, but I think people ought to know all of the things that are looked at before the application for a nursery school is accepted.
so the way that would work, if the council actually approved the language,
Right.
somebody would then come in with an application. We would give them this section of the code and tell them, hey, great, the board's gonna look at these criteria, make sure you hit 1 through 5.
Yep.
We'll schedule a public hearing. There's notice to the abutters then at that point, so the abutters will know. If the abutters had questions, we'd give them the same section of ordinance and say, hey, great, the applicant was supposed to hit, these 5 criteria, so they could be prepared to make a counter argument or something to that effect.
On the specific criteria
That's right.
that we're
right.
talking about, like the ones you read.
That's right, yeah. So the applicant has to speak to those, the board has to make a decision that all of those have been addressed as well.
Yes, okay.
And keep in mind that you,
was hoping.
keep in mind the council won't necessarily know, right? Because, if this gets approved, it's out of your jurisdiction then at that point. It'll be limited to either the Board of Appeals or the Planning Board.
And if there are questions from the people who are applying about, did you consider something, this or that, is that going to be able to be answered at that time?
Ideally, yes. That's,
Okay,
that,
it's not
the
like it's a
board should be
little
asking that
secret
question.
inside.
Well, again, it's written that way because each case could be,
That's right,
specific to the site.
right.
It could be somebody who literally has 1 acre and has houses surrounding them in a really dense area. It could be somebody with 10 acres and in the middle of this lot, they're gonna, and it's,
Matter, yeah.
exactly,
It
so it's
doesn't
gonna be
apply.
site dependent.
Yeah, but I think the appeals board and the planning board need to look at it just the same.
Absolutely.
Say, well, it's 10 acres, it's not, this and that is not going to apply, but one thing that concerns me is that I think the 1 acre is good, the requirement that there be 1 acre, because there'll be a lot of children playing in that acreage. But it does impact perhaps neighbors who don't have 1 acre of land to play on themselves. And so if they're in their yard, they can feel as though they're pretty close in proximity to the business, even though the business has lots of acreage. And so, I'm just talking, I guess, more to my city council here. Councilors, I do want to make you aware of that. That's a problem, I think, that needs to be considered. And probably it is considered in one of those considerations you were talking about.
It certainly could be something that the board considered, but again, I think part of the issue is going to be that they will be considering, is there any additional impact over and above what a daycare would have? So if the daycare can have 12 kids there and they can be outside for 20 minutes in the morning, and the nursery school has 12 kids, they can be outside in 20 minutes in the morning. They're both the same impact there, same thing in the afternoon, although it might be a different group of kids with the nursery school.
And I would argue there'd be a bigger impact because.
And I'm sure that will be what will be discussed, and certainly what the planning board's going to have to take a look at. And just as you do when you do property condemnations, the board will have to issue findings of fact. They will have to rule on each of those individual characteristics and come up with a finding that it meets the criteria in order for them to approve it.
That's particularly important if for some reason they deny it, because if the applicant wants to appeal it or a neighbor wants to appeal it,
Yes.
the city staff needs to know what those specific criteria were as to the denial, because it goes to court after that.
Okay, I just wanted to make sure of that. That's why I asked the question. Thank you.
Councilor Marcotte.
Councilor Beam brings up a good point, that what you provided with sections 2 and 22 definitions and land use requirements, not seeing something specifically here that says whether it's permitted or conditional or otherwise not permitted. Does the Article 11 in District Regulations, Section 22, simply make reference to the chart, which
Yes.
is where we would need to go to?
Correct.
Okay, looking at the chart, this was previously permitted in many of our zones. Is that how, am I reading this correctly?
That's correct.
And it was not previously permitted in NCA. It's now listed as a conditional because of the council action,
Correct.
okay? NCB was previously conditional
Correct.
before this discussion ever happened.
No.
No.
There was no definition of nursery schools before. The action you took was to allow nursery schools a definition. The original amendment that was approved came up with a definition of nursery schools. Nursery schools were permitted in various districts. Then the NCA, when you look at the definition of NCA, it had specific requirements, right? 1 acre, no more than 12 kids, that type of thing. So we added nursery schools to all these districts, because the thought was that if you can do it in the NCA and you can have a child care facility, why can't you have nursery schools in all these districts as well?
So that council action permitted it in the NCB as well, and rural agricultural?
No, that's what we're coming back with. Right now, in the only residential zone it's allowed is the NCA. The proposal is to extend that to the other residential zones.
I thought we were looking at extending it to low-density, suburban residential, and medium-density.
We were, but that note 22 that you see is crossed out, that meant that it was accessory to, I'll tell you exactly what it's accessory to.
Public schools, religious facilities, multifamily or mixed residential developments, and mobile home parks.
Thank you.
But the discussion was to permit it in those 3 zones. Now it's looking like it's not being, sorry for the word permitted. When we put it back to the planning board, we asked them to review 3 districts. And it would continue to be conditional, just like we passed for NCA. But I'm now seeing rural agricultural and NCB, which was never part of the discussion, unless we're adding those 2 zones to the discussion as well and making it 5 additional zones.
What's the 5th one you're talking about, Mr. Marco?
Rural agricultural and NCB.
NCB.
Gotcha. I will need to, I'll need to check with staff on that. I understand what you're saying. You're right, though, as far as the action that was brought to the planning board, it was literally those 3 districts. And it was to put the definition in the same as far as the 1 acre and the 12 children. So I'll need to check with staff on that.
Okay.
Further discussion or questions from the council? Councilor Lyson?
Yes, David, there was some input about how this would open up home businesses. Could you talk about what home occupation are allowed currently in these zones?
So in every zoning district, you're allowed to do a home occupation. A home occupation is accessory to any dwelling unit. There are certain criteria by ordinance that limit you as to what you can do for a home-based business. You're not supposed to generate traffic that would be more than what you would normally expect from a single-family home. You can't have any staff other than people that reside there at the property. You can't have any stock and trade. You can't create any noise or disturbance that would be greater than what you would normally expect from a single-family home. So when someone comes in and they want to do, I don't know, taxes or something like that, they're preparing home taxes, they come in and get a home occupation permit, we tell them, hey, you can do that, that's great, but you shouldn't have a lot of traffic going in and out of your house. We're going to know if you have all kinds of clients there, because the neighbors are going to call up and say, what's this guy have for a business here? You want to go to other people's houses and pick up their paperwork and prepare and meet at their property and conduct business, that's great. You can even have your other employees working for you if you want, but they can't be at your house necessarily. You all meet at the park and ride and you go off somewhere else or something to that effect. But those are the basic criteria for a home occupation. And so you can do that anywhere in the city, assuming you get a permit and you meet those criteria.
Thank you.
Further discussion on the council? Great, thanks, Dave.
When I come back, I'll clarify the district questions that Jolene and Mike asked, and I'll provide you a copy of the conditional use criteria as well, so you folks just have a copy of what they're actually looking at.
We're looking at this for the agenda on Tuesday.
Not this coming Tuesday unless you want it then.
Okay.
We wanted a full council.
I think we should.
Oh, right, for the, okay.
So it would be first meeting in October?
Great. And can you send us that information in the meantime?
Sure.
So we have a chance to review it before that meeting? And our next agenda item is review of the draft marijuana ordinance. Don't go too far. That's a much bigger binder.
He's going to sit down too.
Play with the computer. Oh, I have props. Handful of these. I'm going to throw it up on the screen anyway, but there's a handful of these for anybody who wants them. So, I'm back. So the planning board met on this on the 26th, and they voted 6-1 to send a favorable recommendation on both the zoning provisions and the licensing provisions. And I had them look at the licensing provisions because there's a lot of overlap between the two, but technically they don't have any jurisdiction over the licensing section of the Code of Ordinances. They're really limited to zoning and land use, but again, they're so closely related. They reviewed that section as well. The one opposing vote, I can tell you, I just think that the individual is just against marijuana and relaxing the rules. I think it's that broad. Unless you folks have questions, which I'm sure you will, I'm not necessarily going to go over everything because there isn't a lot of changes here from maybe the last 2 times we've talked, just minor tweaks and nuances. The map I provided you, and I'll throw it up on the screen here as well. Do what I was going to hope it would do here. Hold on here. I don't expect you guys to be able to make a lot of sense of this, but it's without zooming in on it. But what it's doing basically is it's showing you the districts that we allow manufacturing, cultivation, testing, nurseries, and dispensaries. And again, those are the industrial zones, urban enterprise, mill, highway business, and office service. So when you're looking at this tiny map, and I'll zoom in on the one on the screen a little bit too, wherever you see and the hand, so the blue areas, those, when you see just the blue area, that is an area that's just going to allow cultivation, manufacturing, testing, nurseries, dispensaries. If you see a hatch area as well, like what the cursor is moving over right now, that's an area that's going to allow retail uses as well. I guess while I'm on the map, I'll keep on talking because it kind of relates to a lot of the performance standards. Everything that's kind of in the beige type color there, those are residential zoning districts. We'll talk about what that means with respect to establishments. Wherever you see a little red triangle, those are existing locally licensed caregiver facilities. Wherever you see a yellow circle, that is a setback from a licensed childcare facility. Wherever you see green circles, those are city parks, based upon the existing list as the ordinance is drafted today. You folks are potentially going to act on some amendments based upon what you just talked about tonight, where it actually takes out a couple parks. I think there's 3 parks that it takes out altogether, so this map doesn't reflect that. Like Gaslight Park, where my cursor is, that's on here, and St. Mary's Park and another park would be removed here. So that's what the map is showing. I'll get into the specifics of that as examples going on. The areas I kind of wanted to focus on, I think that are important for you folks, and it might be easier just to go to the ordinance itself. So page 4 of the actual ordinance. There's a date at the top of it, says 08/22/2019, and then it says section 22/423. So that's where I'd like to start. And again, I'll just highlight some of these areas. So under section 22/423, I know this has come up at previous meetings, but I didn't get a lot of direction, so I kind of kept it the way it was. But it clearly says, the last sentence of that first large paragraph, outdoor cultivation of marijuana for personal, recreational, or medical use is prohibited. So anybody in the community that wants to grow marijuana for themselves, either as a caregiver or for adult use, has to be inside. We've put that provision in there because we get odor complaints. Most of the odor complaints we get now are from inside. If they can't control the odor inside, how are they going to control the odor outside? My guess is that's going to create heartburn. We're probably going to get complaints, probably going to need the police department's help. But when we get those types of complaints, if it's inside, at least they have the ability to mitigate it somehow. Filtration, doing something. If it's outside, I'm going to tell them they have to move their plants. And that's, they're going to say, oh, well, can I wait until the end of the harvest here? Well, no, if people are complaining now, we need you to get rid of them. So that's something I want to bring to your attention. Last paragraph in that section, unless otherwise allowed, cultivation, manufacturing, testing, or sale of marijuana from a residence is prohibited unless it's for personal use. So again, we don't want anybody, doing commercial operations basically out of a residential setting. That's what it comes down to. The bottom of that page, under section 22/424, the last sentence there, adult use manufacturing out of a residence is prohibited unless it's for personal use. So If you want to do we talked about this briefly. If you wanted, manufacturing includes extractions, manufacturing includes a bakery. If you want to be a home processor right now and you're making whoopie pies and all of a sudden you want to make edible whoopie pies, for primary care purposes, you could do it. For adult use, you can't. So just making that clear. So, because somebody at some point is going to want to do it for adult use purposes, and I don't know, maybe we'll have to revisit it. But at this point, staff's proposing to do it for medical purposes only. We are going to skip ahead to page 7. Under section 22-430, performance standards. So this is really where the limitations are going to come into place as to where a marijuana business can operate in the community. I'm going to say it now, I don't know how well these are going to work. I mean, I have a sense as to how it's going to work, but I don't know if it's still going to allow a ton of establishments or it's going to totally, shut down the industry in Lewiston. I had an interesting conversation today with Portland. They actually want to put a cap on the number of establishments down there. They also want to charge, we'll go over that fee, about $10,000 for licenses down there as well. So they're in a totally different world and perspective as to a lot of other communities down there. Again, what I'd like to do is go through some of the ones that I think are going to be more controversial or things that you guys should be aware of. Starting with number 1, again, no outside cultivation or storage of marijuana products, or related supplies. Just keep it inside. Number 2, this one keeps on coming up, and I'll show on the map an example. Marijuana businesses operating with city approval prior to December 13th, 2018 shall be entitled to continue operation whether such use does or does not conform with the locational requirements of this section, or applicable zoning ordinances, and shall be treated as a non-conforming use. Non-conforming businesses may convert to another non-conforming business pursuant to Article 6. What that's basically saying is, when you look at this map, and I'll zoom in on an area, and we're going to pick on Lisbon Street because that comes up a lot. So these red triangles are where we're aware of that people have licensed establishments. Great, you can see the hatch mark kind of in there that suggests that these are retail, and retail would be allowed in these areas. You can also see it overlays with green, it overlays with yellow. Chances are, if we got more specific with this, my guess is all the establishments downtown are probably non-conforming because they're in proximity to a park, most of them at the Frame Plaza. Kennedy Park, they may be within distance of that. They may be too close to each other, which isn't even something we're talking about yet. My point being here is that these establishments, if this is passed the way it's written, they would continue to be allowed to operate. Be retail to retail, that's fine. Somebody closes, somebody buys it within 12 months, wants to do retail there, that's fine. All of a sudden they want to do, and actually in this case, that's the only district that they can only do retail in this area. Maybe if I pick on another area as an example, we'll pick on this triangle here, to have the cursor around. That is a retail establishment right now. It is non-conforming. That big purple line behind it is a residential district. There's also a daycare somewhere in that area there. They can do retail, but all of a sudden they say, I don't want to do retail anymore. I'm also in a zoning district that allows me to do manufacturing. They can't do that as a matter of right. They would have to go to the Board of Appeals and argue that they're going from one non-conforming use to another non-conforming use. That's not necessarily a no-brainer. It's going to be a case-by-case scenario. They're going to have to demonstrate that they're no more offensive, no more non-conforming than the current use, that they're not going to generate more traffic, that they're not going to generate more odors, that it's not any more noticeable than what's already there. So there's, similar to the conditional use criteria that we were just talking about, it's a series of criteria that they're going to have to meet, and the board's going to have to make a judgment call on that. I understand in talking to some caregivers that creates, some nervousness and heartburn because they don't know what the future's going to hold for them necessarily. What I can say, the way we've drafted this, is because right now we only allow medical, and we're talking about regulating medical and adult use as the same group. Any of these guys, these businesses that want to go from medical to adult use, it's going to be one category, so they're going to be fine in that sense. So we're not necessarily saying that you can't go from retail of medical to retail of adult use. Retail's retail as far as we're concerned. Grow to grow is the same. It's when you start changing. So if all these businesses want to get into the adult use side, which I think a lot of them are going to, it's probably not going to be an issue for them. It's only going to be an issue if they want to actually change to another use, testing, manufacturing, cultivation, things of that nature. Number 3, this is the setback from schools. So that is a lot of your, let me zoom out here again just to make sure I'm getting this right. School properties were blue circles on here, and actually I'm not sure that that's actually.
I think they ended up being green. If you look
Yeah, I
at
think so,
Franklin
too.
pasture, it's all green, but of
Yeah.
course, that's also park, so.
Yes, well, and same with like North Temple Street,
Dave
McMahon.
Reed, you open to questions as we go along.
Sure.
Counselor Pengill?
Just in where we've now created nursery schools, does it fit within this criteria, or is that something that needs to be
You know-
adjusted, where we just created this essentially?
I don't think so, and I knew you were going to ask that question, and I didn't come prepared, so shame on me. But under section 3, where as you go through this here, it talks about what there's setbacks from, and it talks about school as defined in Title 20A, blah, 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 blah. It also goes on to say the term child care facility means child care facility that's defined in section 22 MRS 831. I will check, but I'm quite certain that section, that definition of child care facility includes nursery schools. So yes, to answer your question.
Okay.
And this map, when I get the, so the yellow circles on here, the state gives me that list. I can confirm for you yet that there isn't one nursery school in town, as we've all heard. And it was listed with all the daycares. So that's a good point. I mean, the definition, to follow up on that, we're using the state's definition of what a school is. I'm using that same section of parks and playgrounds and everything that you folks just looked at, section 54-8, so there's consistency amongst, what schools and public areas we're regulating. And then child care facility using the state definition there. What folks need to understand is that there's the important sentence, 3/4 of the way down this, setback shall be measured along the ordinary course of travel between the main entrance of the business and the closest lot line of the pre-existing school or child care facility, park, playground owned by the city. So it's not door to door, it's property line to property line. And that will make it difficult for some people. If we pick on Franklin pasture, right? I mean, Franklin pasture, again, is kind of this huge area here that I'm putting a circle around. All these blue dots are the schools out there. We have caregiver operations that, as the ordinary course of travel, you would never get there, but from you would be well over 750 feet. But if it's to the existing lot line, you're going to be there. Just making folks aware of it. It's not to say that we can't change these things, because I think we're going to change them. Quite frankly, I'll forward to you folks an email I got from MMA. The legislature has another 15, 20 bills that were carried over from the last session dealing with marijuana alone. So how they're going to impact this, I don't really know. But again, just want to make that clear that it's going from the main entrance of the business to the property line of the school. And some of the schools have huge properties, right? So that's potentially going to limit where some of these establishments are going to be. Page 8, number 4, there's been discussion in the past about separation of marijuana stores and dispensaries. So the way this is worded is the minimum distance between the marijuana store and dispensary and any other 2 marijuana stores and dispensaries in the same or adjoining zoning district shall be 500 feet as measured along ordinary course of travel between the main entrance. So basically, the third establishment has to be more than 500 feet away. You can have 2 right next to each other, you can have 2 within 500 feet, but the other one has to be over 500 feet away. That's the same language we use right now in our ordinance for, I know we do it for drinking establishments, I know we do it for adult business establishments. I think we got rid of that criteria for tattoos, I'd have to double check that. Point being is, we have establishments now that probably end up becoming non-conforming because, you know, there may be a third establishment within 500 feet. And that one, that measurement's different, that one is door to door, you know, so I'm standing in the front door here and I'm gonna measure to the front door of the other business. They could abut each other back to back on blocks, right? You know, so the buildings could actually touch each other. Say it was like a building on Lisbon Street and Park Street, but you'd have to walk all the way around the block to get to it. You know, that would be clearly over 500 feet then, so they'd probably be okay, even though there might be like an alley entrance for fire or something like that. The state is going to allow, as I understand, retail to occur of both medical and adult use, essentially out of the same property, but they have to have separate doors. It can be the same business, but this door and this side of the business is adult use, and this door and this side of the business is recreational, or excuse me, medical. I know there are a couple businesses in town that like to be able to offer both. The way this is written, they're probably not going to be able to. I think this only impacts, you know, a handful of the existing establishments in town. But if there's already an establishment on Lisbon Street, if there's already two establishments on Lisbon Street right next to each other, essentially, and one of those businesses wants to add a third door so now they can sell a different type of marijuana, they're not going to be able to. They're going to have to make a decision, we're either doing recreational or we're doing medical, one or the other. So that's something for you folks just to be aware of. It came up last time, it came up at the planning board, I'll bring it up again, number 11 on page 9, home delivery. Basically, it says marijuana businesses are prohibited from providing delivery services, provided, however, that registered caregivers and not medical assistants, unless they are also registered caregivers, may provide home delivery service. So only if you're a caregiver can you provide home delivery service. You can't deliver adult use marijuana. I understand there's a bill out there that's talking about making that, changing those rules up so you could potentially have more delivery services available. It was also brought up, I think, at the council and certainly at the planning board meeting that, you know, if we prohibit this because we're being more restrictive, that doesn't keep deliveries from occurring in your community. They'll call somebody over in Auburn and they'll make the delivery. Okay, you know, that's fine. But if we don't want that service to be housed out of Lewiston, then that's how we have it written at this point. So again, if there's concern about that, I need to know.
Can I ask a question about that? So there's registered caregivers and then there's medical marijuana assistants. You may or may not be able to answer this, by the way. What is it that registered caregivers, like, what are the qualifications for each of those things? Like,
You're right, I can't answer that.
okay. So
I
when we
bet there's
come to
somebody in
public
the room
comment,
who can.
Can you answer that for me?
I'm sure there
When we
is.
come back to public comment, will you answer that for me? Okay.
I might point out on delivery service, it is possible that we could restrict delivery service in the community from anybody outside the community as well. Enforcing that might be difficult, but I think we could legally do that.
Back to you, Dave.
Still on page 9, number 16, I think that's where I want to go, yeah, cultivation of marijuana within or on the property of multifamily dwelling is prohibited. That's a current provision in our ordinance, just kept it there. If you talk to the fire department, they love that. I mean, we've had issues with people doing grows in multifamilies. Ideally, you know, the landlords would be all over it, but in some cases they're not. And we've had it, I mean, it's been some time since we adopted the standards. I think it was 2009, but I think we've lost 2 buildings and had a number of other fires as a result of grow operations in multifamilies. The last one that I think is a limiting factor, and when I say limiting, I'm talking about all these setbacks, is 17. Businesses may not be located within 300 feet as measured along the ordinary course of travel between the main entrance of the business and of a legally established dwelling in a residential district in existence prior to the establishment of the business. What I should actually, I thought this after reading this out loud to the planning board as well. To make it clear, the intent of this is the main entrance of the business and the main entrance of the dwelling. And I will change that. But again, that's something everybody really needs to be aware of. And that may or may not be restrictive enough depending on what the council's purview is on this. So when you're looking at this map, and I'll pick on Lisbon Street. So the section of Lisbon Street here is kind of by J&S Oil, Holy Family, that part of the world. These bold purple lines are the zoning district. So everything inside the purple lines is a commercial zoning district. It's hatched. It allows retail operations to occur. Everything outside of that, in those beige areas, again, is a residential district there. So you could be immediately abutting a residential district, and unless I measure 300 feet between the main door of that business and the main door of the house, if you are closer than that, you're out of luck. You still could be right next door, and it could be more than 300 feet, and we would allow it to occur. And you know what it says, because that's going to be, I don't know that that's going to be an issue, but the comparison was coming up to a convenience store that sells alcohol, beer, wine, and liquor. There's no setbacks. It can be right next to the property line. All there is a row of trees there or something. Should we be treating them any differently than a place that has marijuana? I don't know that everybody coming out of a retail store is all of a sudden going to, start smoking in the backyard or something. But there's nothing that keeps people from smoking cigarettes in the convenience store parking lot either. But I just raised that because I don't know if we're going to run into concerns from residential uses, saying, hey, you just allowed a marijuana business in my backyard. Yep, but if I measure from their front door and I go all the way to your front door, well, if you measure to my property line, it's only 150 feet. Yeah, but if I measure to your front door, it's more than 300, and they're all set. Those criteria, all those setbacks from schools, from residential zoning districts, a residential use in a district, parks and playgrounds, and the separation of establishments from each other. Those are the biggest criteria, I think, that are going to potentially limit where establishments are going to occur in the community. Still, there's plenty of areas, when you look at this map, there are areas out here on outer Lisbon Street, you could have a row of these things, it won't be a problem. I mean, they'll have to be 500 feet away, the third one would have to be 500 feet away. But there's plenty of areas out on outer Lisbon Street. There's sections on Sabata Street, not as much on Main Street. Downtown gets closed up pretty quick, though, because we have so many public spaces in the downtown area, and/or because there's other establishments there that are grandfathered and you're not going to be able to get next to them. I still get phone calls. I'm a broken record, but it's every other day I get a phone call, mostly about retail, but still some people want to do grows as well. So we're absolutely going to have more people applying for licenses. I don't know if it's going to be an onslaught once the council approves this, if we have a ton of them or not. We'll see. With that in mind, I handed you folks that cost comparison sheet. So, just to give you an idea, and I don't know whether or not we should revisit this or not. When I originally did this, I was kind of just looking at Auburn and some other communities, but then talking with Portland, they actually did Portland and South Portland. So it's just to give you a perspective. Some of the communities are regulating the uses somewhat differently as far as high hazard manufacturing versus manufacturing. We're putting it all into one group. But this is the fee structure that we proposed at this time. I can tell you Portland's is as high as it is because they are planning on staffing a bunch of people through their fees. I want to say it's anywhere from like 3 to 5 people they plan on funding through all their applications. They also, and then maybe something we want to consider, they actually have a initial application fee as well. So, for example, if you look at Portland's column and it says Tier 1 cultivation 500, well, that's the annual fee, but the first time you come in, if you're the new person for that, there's a $500 application fee and then another $500 fee on top of that, and then every year thereafter it would still be $500. We don't do that with any of our licenses right now. It's just a flat fee every year. There's no initial application or processing fee.
What's the difference between manual manufacturing and high-hazard manufacturing?
That's a good question. I think what Portland was talking about is the extraction process, and I'm trying to keep us out of that because it's really driven by the state to begin with. When they're using highly combustible materials, they have to get licensed by the state to do that anyway, so that's going to throw up all kinds of red flags to us. It's going to be in one of those industrial areas anyway, so ideally it's probably zoned appropriately, but for whatever reason, Portland's looking to break those categories out. The other thing I would make clear, we have establishments in town that are currently grows. We have establishments that are grows and retails, and then we have establishments that are just retail. And I had a cheat sheet with that. Altogether, there's 33 licensed establishments right now in Lewiston. 16 of them are grows, 13 of them are retail, and 3 of them are both retail and grows. So going forward, the way this is written right now, and I should probably make it more clear so there isn't a question about the intent and whatnot, each establishment, each business type would need a license. So if I'm a retail and I'm a grow, we're going to be charged, that's going to be 2 applications, that would be 2 fees. If the council wants us to do something differently and says, well, if they're doing, I don't know, you take the higher fee of the 2 or something like that, we can consider doing that. But if I have a business that comes in and says, hey, I want to do manufacturing, I want to do a grow, and I want to do retail, so I'm going to grow it, I'm going to break it down, and then I'm going to make edibles, and then I'm going to sell it all, and I would be saying, great, that's 3 different licenses, and that's 3 different fees. That's all I got.
Counselor Lyson.
David, we talked about, I think it's to force someone who's growing for their personal use not to be able to do that outside, it just is not logical to me. Again, we have exemptions, and I know it's linked here with people who are growing as a primary caregiver for themselves and or for personal adult use. But again, I think we talk about for personal use, I think I would like to see this amended to allow them to cultivate that or to grow outside. And they're only limited to a certain number of plants anyway. I also think that if we wanted to, it's clear the odor is going to be an issue inside or outside. But if it's limited to personal use, the amount of plants is minimal. I think it's more dangerous to say you got to grow it inside. You got to get your lights. You got to get maybe chemicals, blah blah blah. And what I've heard is that people, if you're going to grow, you got a growing season here in Maine. You grow other things. Why? It seems, and again, I'm only talking about personal use. I'm not talking about businesses, and I'm sure people here, but maybe in the testimony later, people can talk about personal use and why wouldn't you be able to grow outside. So I think that exemption, clearly for personal use only. I'm not talking about caregiver, I'm not talking about a business or whatever. But knowing where some of these locations of things are and being able to smell them off-site, I go by in a car, in some of the locations, the odor is pretty strong.
So for the benefit of the council, so adult use, you can have 3 mature plants, 12 immature plants, and an unlimited number of seedlings. And for medical marijuana, you can have 6 mature plants, 12 immature, and an unnumbered,
Is that for personal use, though?
So personal use would be adult use.
Adult.
So you can have 3 plants yourself, and you can have 12 immature ones. If you're a caregiver, for medical purposes, you can have up to 6 plants. So you're gonna have 3 plants, your wife's gonna have 3 plants, your kid's gonna have 3 plants, the dog has 3 plants. I mean, it's just, so, but I'm just,
Yeah.
that's fine, you know, but, I mean, that's what I need to hear
I
from the
just think,
council.
I
is-
just think it's, again, limiting it to only, if you're growing for personal use, why couldn't you be able to grow it outside? It just doesn't make sense.
And that's fine. I would suggest then we still probably need, if we're concerned about odors, because that's primarily the complaint we get.
Yeah,
Our
I mean,
office
you can
doesn't.
keep the odor language there, but just, right now, it's prohibited. You gotta do it inside, and there's exemptions for other things, especially, specifically here, it's, again, for
You
personal
could
use.
also look at limiting the number per property, number of plants per property, if you were worried about a large family and 40 plants out back.
I mean, if we're gonna talk about making amendments to outside growing, then I would need for us to look at a limit on the number of plants per property. Counselor Ray?
Just in reaction to that, I think I differ in opinion from Councilor Lyson. I think keeping things indoors is a better idea for everyone, in my opinion.
I mean, I think we should, before we start talking about amendments, we should probably figure out, as we're talking about these things, like who's in favor of what, so that we know kind of what, if Dave should put the time and effort into making amendments before
I mean, it
he
is,
spends the time
I
making
guess
amendments, whether
I
it
also
is
have
or
to
is not.
understand what indoors is. Does indoors mean in a brick structure or in a greenhouse? I mean, I think, pardon me?
Greenhouse seems fine to me.
So we have a definition of enclosed locked facility means a closet, room, or other enclosed area within a building or an enclosed locked facility within a greenhouse that is equipped with locks or other security devices that permit only access by the licensee.
But if it's for personal use, they don't need they're exempt from getting a license, right?
That's correct, so that just has to be inside that. I mean, you're right, we don't, that definition is targeted towards a licensed establishment.
Right.
Counselor?
So I have a number of thoughts besides just the outside provision, and then a request when we move into public comment. And this is maybe silly, and I apologize, but understand it, I do not know how much marijuana costs, or like what quantity people purchase it in. So it would be helpful to kind of understand what the kind of scales are from the businesses.
Can I just follow up on
Is
that
that-
also?
yeah.
Like, in
feel
a
so
similar
stupid, I'm
vein,
sorry.
like marijuana plants, like how big are they? Are we talking like sunflowers? Are we talking about like, do you know, so when we're talking about 3 plants, we're talking about 3 sunflower-sized plants? Or like what are,
I would defer to these guys, they'll know better.
okay.
So maybe during public comment, folks could share a little bit of
Yeah,
that.
that'd be
And then when you were talking about the licenses and fees, I would definitely be in favor of keeping them as separate for tracking purposes as well. So if, you know, as you were saying before, if there's a grow and a retail and they dissolve the retail part, it would be helpful to know that by tracking the licenses over time. Again, outside, not really into that. And I know we didn't provide guidance on that to you prior to now, but as I'm looking at the whole of proposal, I think that makes the most sense, unfortunately. I'll leave it there. Thanks.
Councilor Marquardt?
Coming back to the fee schedule comparison, Tier 4, I noticed that no other community has Tier 4.
Yeah, I'm not sure why. Tier 4 is to allow cultivation up to 20,000 square feet. So I don't know why that is, actually. I noticed that, too.
So what would be Tier 3?
I think I have that defined. Maybe, maybe not. That's regulated by the state just for medical purposes. So they would be telling us, because they have to get a conditional, before they can operate for adult use, they have to get approvals from their municipality. Give me a second, Mike. I probably have something that tells me what the square footages are.
That's the reason basically the difference between each of the tiers, square footage.
I guess I don't have that with me, Mike.
7,000 square feet, does that sound right? I mean, I don't know how big a marijuana plant is, but apparently I know what tier 3 is.
Yeah, I know that this for, I don't have that with me, Mike, I'm sorry.
Looks like the chief knows.
Dave, Tier 3 is 2001 to 7,000 square feet, and Tier 4 is 7,001 to 20,000 square feet. It's in your handout.
Oh,
Thank you.
thank you.
And I noticed that for the first 3 tiers, we're on par with City of Auburn.
Correct.
For the fee schedule.
Correct?
Correct, okay. I didn't hear that. And then we considerably lower than Auburn on the next 4 categories of
When-
manufacturing and retail.
Yeah, when I initially put this together, there were not, I think I did this back in either May or June. There were fewer communities that had fee schedules out there. And we were kind of going into our uncharted territory anyway, because we were looking at adult use, and a lot of communities hadn't. So there were a number of communities that had lower fees at that time. So I was trying to pick something in the middle ground. I believe at one of the council meetings, folks were asking like what liquor license prices were, fees for that, and I provided that at one of the workshops. So I was trying to be mindful of that. But that said, when you start looking at some of the other larger communities, yeah, our fees are less there. So that's certainly something that you folks can consider.
Dave, would it make sense for us to revise those and come back with a recommendation?
Well, absolutely. I mean, this was kind of the recommendation at this point, but if the council wants us to look at increasing those, certainly we can do that. I can look at more communities if that's your pleasure. If you want to be more in line with neighboring community, we can do that as well.
These are annual fees?
Correct.
Generally, we have tried to stay pretty consistent with Auburn in terms of fee schedules for almost any, a lot of our permits and licenses.
So medical retail would already be set though, right? Because we already have medical retail?
But we can change it. So right now, it's $550.
Okay. So this recommendation is even beyond what we're currently charging?
Correct. Yeah, that's a good point. What we charge people now for anybody who has a local license is $550 annually.
Other questions on the council before I open it up for public comment? All right, so if anyone wants to speak to this item, please step to the podium. Actually, can I get you to answer some questions? So first of all, the one question about the differences between the,
Caregiver and caregiver assistant?
yes, please.
Yes, so at the moment, a caregiver
Sorry,
assistant.
can you just state your name and address for the
Yep, I'm Alex McMahon. I live at 40 Lisbon Street.
Great, thanks.
So currently, a caregiver's assistant can do everything that a caregiver can do, and they go through the same background check through the state that a caregiver would go through. So there's essentially not much of a difference. It's just slightly less of a fee to the state, but they still can handle product. They could do transactions on behalf of the caregiver. They can collect payment, interact with customers.
So do you have any sense why it's set up differently in terms of delivery?
It's on the state level, it isn't. So
Right.
on the city level, I'm not sure why it would be set up differently.
We did that in part because we wanted to know who the person was.
Okay. That's helpful. And then, I think that's all I have.
Size of
Yes,
plant?
plants, yes, thank you. So how big is a marijuana plant?
It can vary in size, it could be as low as, a couple feet high, it could be a decent amount higher.
Okay.
Indoors, you're limited by the space. Outdoors, they can get pretty big.
Okay.
So my clarification was on the caregiver assistant versus caregiver. Would it be more appropriate for the language to talk about the business license holder in that case then? Instead of that distinction, since it seems like there isn't one at the state level? Is that what the essence of what that clause is trying to do, Dave?
Well, I think that what he's saying is that the state doesn't differentiate between the two in terms of who can make the deliveries.
Okay.
When, the way this is, the intent anyway of how it's written is, if you're applying for a local license for a marijuana business and you're doing retail and you want to do delivery, the license holder, they're demonstrating that they have their appropriate approvals from the city. They may be a caregiver. They give us a copy of their card so we know who they are. It may be a good question for Alex, because I don't know what kind of evidence an assistant gets, to demonstrate that they are, versus anybody else in their establishment, just, hey, go make a delivery type of thing. But the intent of that was to know who's making a delivery. I don't know that we'll ever run into an issue, but if PD pulled somebody over and they had a bunch of product in their car, who are you, where are you delivering this from, especially if we're talking about what towns it's coming from, if we're prohibiting people from delivering from other communities and whatnot. I think we're gonna need to have that information if we're truly concerned about it.
So do assistants get cards?
Yes, so the card is actually the exact card that a caregiver receives. It just starts with CGA and the control number instead of CGI. So it's the exact same card.
So if the council wanted to, and I'll have to give this some more thought, but if we're inclined to continue to allow deliveries in the community for medical purposes only, we could somehow make a distinction on the application. Like, I guess they would have to let us know, like, who your employees, who else in there, give us the evidence that those people have that card, so we know that, these people are making those deliveries. And that's, I mean, it's as good as it's gonna get. I mean, if they hire somebody else, it's really their responsibility to come in and amend their license, and we'll know that annually, either that they amended, or if they get themselves in trouble for some reason and they don't have a license, well then, great, they should have, and there'll be consequences at that point. So, again, that's kind of up to you folks. To the mayor's point on a lot of these things, it'd be great to have thumbs up or thumbs down at some point, so I don't keep doing the same mistakes over and over.
So are there things we've already brought up that we need to do a thumbs up, thumbs down on?
Well, to your earlier point about whether or not we want to allow outdoor for personal use, whether it's adult use or medical marijuana, that would be good to know, because the way it's written right now, it's clearly no. Same with deliveries, and maybe other issues will come up as we talk.
Okay. So do you want to keep a running list of issues, and we can do thumbs up, thumbs down on them at the end?
Sure.
Great. Other questions on the council? All right.
So while we are on the topic of delivery, I would like to touch on adult use delivery. So I know you mentioned that the city could take steps to prohibit other municipalities from delivering here. I'm not, I don't claim to be an expert in politics by any means. All I know is what is happening on the state level, currently in the proposed bill that's sponsored by Senate President Jackson and co-sponsored by our local representative, Representative Jim Handy. It does say in, so the bill title is 129 LR 1888. In subsection 504A, it does say that a marijuana store may operate a delivery service from a marijuana store's licensed premises. And now, so this part is important. It's a marijuana store, so it's a store that's gone through all the licensing requirements of the city and the state. It's not just a delivery service that won't be allowed. It would be a marijuana store. So a marijuana store may operate a delivery service from a marijuana store's licensed premises or locate a storage facility only in a municipality that has authorized the operation of a delivery service under section 402, subsection 3, paragraph 4, or paragraph B. A delivery service may deliver to a recipient located in a municipality that has not authorized the operation of a marijuana establishment or a delivery service under subchapter 4. So again,
That's just pending legislation?
that is pending legislation. It does have.
Right now, under state law, delivery is not allowed, correct?
Yes, so at the moment, delivery isn't allowed, so on the state level, if it's not allowed, I feel like there wouldn't necessarily need to be any action on the local level. But if it were passed, it'd be passed with the support of our local representative. And if Lewiston has an ordinance in effect that would prohibit delivery,
I would just strongly recommend that we not pass a law that's contrary to state law, that if we were going to do that, we do it after the state law has been adopted, because it would be confusing to people who are just looking at our ordinance and say, oh, Lewiston allows delivery. They may miss the fact that it's a violation of state law.
So,
And there's usually time. I mean, you're talking about, unless it's emergency legislation, you're talking about, wasn't it 60 or 90 days after the end of the session before a new state law goes into effect.
so we can leave it to match the state law for now, and then if the state law changes, revise it to match the state law.
That would be my
if we choose
recommendation.
to do that.
I'd be very uncomfortable and feel like we were potentially misleading people to think that, oh, regardless of what the state says, the municipality has the authority to do what it wants and it's allowing it.
So it is an emergency piece of legislation, just to make that known. Also, I wouldn't be requesting that the city of Lewiston put any language in favor of delivery. I would simply be asking that the city of Lewiston doesn't put any language in opposition of delivery, so that when the state makes its call, Lewiston businesses won't be left behind the curve.
And we're talking about adult use.
Adult
Correct.
use, yes, correct. I would also like to point out that Representative Handy is not pro-cannabis by any means. He has voted against cannabis on a number of different topics. He is pro-public safety. So cannabis delivery, it actually isn't a new thing by any means. It's been happening since before the medical market even. It's been happening since cannabis and cars have been a thing. So currently, if a friend of your son is at Bates University and they want to have some cannabis delivered, would you prefer if it were delivered by somebody that has passed a state background check and is delivering a licensed product or an approved product on behalf of a licensed store, or the alternative, it's delivered by whoever they could find on Craigslist, and they could have a background that could be, of questionable, any number of things, and it could be, a product that has mold, or essentially this is about regulating what is already happening so that we have an increased public safety. That is all I really have to say about delivery. I know that you all have heard me speak on this topic at least a couple of times. We just don't want to be left in the dust. I do want to speak a little bit on, so I did pass out a document to everybody beforehand. And I apologize, Counselor Marcotte, did I leave one on your desk?
There was nothing on my desk when I arrived.
I apologize. Okay.
So public comment is usually 3 minutes long, and you're past your 3 minutes, so if you can try to move through this quickly, that would be great.
Yes, certainly. I
Thanks.
apologize.
No worries.
So I did just want to bring to everybody's attention that there is a bill up at the state level that is proposing a 12% kickback to the municipalities that generate the revenue. So that's huge. It's also backed by MCIA and MMA, which is big. Those are groups that have gotten some heavy lifts accomplished in the past. So just wanted to make sure everybody's aware of that. And then my last topic would be the co-location issue. Right now, if 2 stores are within 500 feet, a third couldn't exist, which I do understand the city's perspective on that. We wouldn't want multiple frontages. Basically, we don't want the industry taking over where other industries are actively doing business. I think that if they are at the same address, I believe that the impact on the city and the impact on the street is going to be essentially the same. it'll still be, so for us, for example, we're 40 Lisbon Street. For as far as the public knows, 40 Lisbon Street is a marijuana store. If a store were to open up upstairs, 40 Lisbon Street would still be a marijuana store as far as the public is concerned. If we have to choose between adult use and medical, we will most likely have to go with adult use, but we would sincerely not like to have to abandon our medical clientele that, have grown used to buying products through us, getting a reliable product. And with adult use, it's going to be different regulations. They're not going to be able to get some of the products that they may need. I know I went a little bit over time. I appreciate everybody bearing with me. Thank you.
Thank you.
Yep.
For what it's worth, Mayor, I have a note from MMA too regarding the bill that he referenced. LD 335 has already been enacted in the House and Senate, but needs some support from Leadership and Appropriations Committee to make it to the governor's desk. And that apparently would get 12% sales and excise tax revenue to generating municipalities.
Just, yeah, by way of
So it's sitting on
background,
the appropriations table is what that means.
by way of background, that was included in the original referendum. The legislature removed it, I think primarily on the basis that the legislature has this insane fear that if they allow local governments to do something in way of a local option or a local tax, that we might want to do it in other areas and it might open the floodgates, and before you know it, we would be taxing the universe and the state wouldn't be able to tax anything anymore. I'm being obviously a little overstated there, but that was the reason it got taken out.
Anyone else from the public want to speak on this item?
Hi there. Before you start the time, I'd like to bring a point that might be important to you folks. My name is DJ Searles, and I operate the store, Garden of Whedon, located at 942 Main Street in Lewiston. The point that I want to bring up that's important to the committee and council is when you folks were talking about regulating home use and personal grow, that's actually going against the Maine state law that's already in effect. I don't know if you want to write this down, but Title 28B, adult use, personal use of marijuana, subsection 1502, it states that hang on. It basically, if you read it, I was just trying to find it, but it states that the city may basically tell the people that you can't have and grow on your parcel of land for everybody. But what you can't do as a municipal is, and this part I did find, a municipality may not generally prohibit the home cultivation of marijuana for personal use within the municipality, restrict the areas within the municipality in which home cultivation of marijuana for personal use is allowed, or charge a license or other fee to a person relating to the home cultivation of marijuana for personal adult use within the municipality. So it states right there in Maine state law that you can't make a law that states that folks can't grow outside of their home for personal use or grow inside of their home. I believe there's also a very similar law regarding medical cannabis, stating that municipalities may not, because I heard that you can't grow in multi-structural buildings. I believe there's a law stating that as a municipality you can't do that. So I do have other points to make, but I just wanted to bring that up because...
I can say for the council's part, I'm aware of that section. We can certainly look at it. I'm not sure that's the way DJ's interpreting is the way that other people have interpreted, but we can make sure that that interpretation is correct. And if there's an issue with an ordinance, then clearly we'll address it.
One of the things we will do in the near future is we will ask for our attorneys to review the draft of the ordinance we're putting together, see if they see anything that we need to be concerned about. I guess our argument in that case, in this instance, would be we're not prohibiting it. You can grow in your house.
That's right.
Or in an enclosure. We're not prohibiting it. We're just regulating it.
So I just want to point out that you have a very little amount of time left of your 3 minutes, so if you can wrap it up, that would be great.
Well, that portion, as I stated in the beginning, that wasn't important to me. That was important to you folks making the laws. I'll speak on what's important to me now. Limiting the business hours, what are the limitations for the business hours currently?
The question was limiting business hours?
Yes.
We're not addressing that. We haven't spoken to that.
Okay, all right. And we're speaking on the delivery servicing and the employees? I heard you guys speaking on that, right? Okay.
You can speak to anything in the ordinance, but again, you have 3 minutes to make all of your points at once.
All right, well, limiting the business hours affects me personally. We're located on Outer Main Street. We don't have the luxury of being in a high-traffic area with a lot of walk-around traffic. A lot of my patients do meet after hours when they get out of work. You know, they get out of work at 11:30, 11 o'clock at night. I've got folks that are cancer patients that do traveling for radiation and chemo. You know, these folks call me up late at night and say, hey, you know, I'm in a lot of pain. I wasn't able to make it out of the house, or I just got out of work, things like that. I just got a call 2 nights ago it was just about midnight. Hey, I'm in tears. I don't know what to do. Stomach ulcers. I went down. I took care of their medicine. Limiting the business hours would prohibit that. I understand when it comes to bars, you know, you've got people showing up, loud music, people are drinking, they get a little wild, there's fights happening. That doesn't happen at a store. People come in, they leave, or I deliver it right to their home. As far as the employees go, when it comes to delivery services and only allowing the employee and not making it just so the caregiver can do it, I believe that opens up when Mr. Hedegaard mentioned, well, we just want to know who they are. Honestly, I believe that opens up to police harassment, and I'll give you a case in point. Currently, law enforcement officers can't pull you over unless they suspect you of committing a crime. I have dealt with, in Scotland County, on some multiple levels of harassment personally, things that have been documented, and I've had to deal with my lawyer. The other night, leaving one of my business facilities in Lewiston that's licensed, I got pulled over. The primary reason why I got pulled over, and the first question out of the officer's mouth was, what are you doing over there? What do you mean, what am I doing over there? Yeah, well, what were you doing over there? Well, honestly, that's none of his business. I wasn't committing a crime, but in reality, I was checking to make sure my door was locked because my camera went off, because a cat was outside. That's all I was doing over there. So I believe that if you limit it to just the caregiver, that opens the rights to law enforcement officers to say, we don't think you're the caregiver. When in reality, the caregiver employee has to go through all the steps, as Alex was talking about, the state background checks, all of the licenses. So those are my points.
Great, thank you.
Thank you.
Anyone else wish to speak to this item? Sure. So again, I just want to remind folks it's a 3-minute.
My name is Phil Fournier, 711 Lisbon Street. I'm the owner of Small Batch. My first point is in regards to deliveries. I just want to bring up the point that a lot of patients that use medical marijuana and recreational people that haven't gone over that way are unable to get to the locations to provide themselves with such medicine. They're restricted, you know, invalid, can't move, sick. I think restricting deliveries is really restricting the overall use of medical marijuana. Recreational is definitely something to consider differently, but as medical marijuana establishments, we need a way to get product to patients that can't get to us. I also wanted to bring up the point on that, that each delivery would be restricted by a trip ticket. So upon delivering, you would have to have a piece of paper that said what you're bringing, why you're bringing it, or not why, but what you're bringing and where you're bringing it, what time, how much, and where it's coming from. So you kind of cover all your legal obligations there as far as your worries about where it's coming from and who's doing it. My second point here is in regards to the business expansion / growth, excuse me, in relation to the use of change of basically, in my opinion, the future of a successful marijuana business in our industry will have 6 major divisions. You'll have your grow, you'll have your storefront, you'll have your lab, you'll have your kitchen, you'll have your delivery, and you'll have your wholesale market. By restricting, basically your ordinance here is enabling us to be grandfathered as retail stores or grows. But if you don't have an established medical or delivery or kitchen, you're basically excluding businesses from growth potential. And because of the restrictions of the 350 feet, my business, which is right on the line of a residential, operating now as a grow, would not be able to wholesale manufacture extracts or medical edibles, which would restrict the growth of our business. And honestly, I can wholesale flour currently in my zoning. I can move flour to other caregivers and stuff like that. What's the difference if I'm making edibles for my patients if I can make bulk of it under the restrictions and whatnot of the city and the state as far as the laws of making safe food in a safe kitchen that is certified? Why can't I wholesale that? So basically, the zoning and the 350-foot setback would hinder my business from growing. And I think that's something that you all need to take into consideration as far as we are operating right now as successful businesses, and enabling other businesses to come in and do the same things that I'm requesting is an unfair advantage. The third point I have is...
So you're past time, if you can wrap it up quickly, that'd be
Okay.
great.
In every state, medical has been absorbed into either the recreational or it's just died because the market is absorbed by recreation. So this is in regards to the dual use, the recreation and medical. I'm asking that the medical front be allowed to operate in the same establishment. And this is under state law that they would have 2 separate doors. In other words, as the overlap happens over time, recreational is going to absolutely kill off the medical program. So what we're asking is that you enable us to operate both so that we have an overlap of time, and eventually the medical will die and we'll just be recreational. Something to take into consideration. My final point is the limitation of business hours in regards to what DJ was bringing up. I feel the same. Patients, they have different schedules and they need different times. So limiting our ability to provide these services is kind of restricting and holds back our business growth and the potential to provide a product to people that need it. Sorry for the overlap.
Great, thank you.
So just to be clear, Mayor, there's nothing in here that talks about hours of operation.
Anyone else on this item? All right, so Dave, you had a list of,
Sorry, Dave.
Yeah,
I was just-
absolutely.
I think I got a little lost. I keep getting lost along the way. It's so much information. I appreciate everyone bringing their stuff. Currently, is medical delivery allowed by the state?
Yes.
Yes, but you were saying recreational is not allowed by the state?
Correct.
Okay, thank you.
To Councilor Marcotte, what the chief was referring to, the very last page of your package has the square footages for all the tiers on there.
Last page.
Yeah. As far as a running tab here, I guess, there's 2 sections, I guess, that apply to whether or not we're doing, allowing outside grows under 2243, 22-423, that's on page 4. There's language there that says outdoor cultivation of marijuana for personal, recreational, or medical use is prohibited. Similar language is found on page 7, number 1. Maybe a distinction between the two could be because under 22-423, basically that language is saying when you don't need a license, the idea is to allow people to be able to grow for themselves, both recreationally and medically. Maybe that's the section where the change occurs if the council feels that's appropriate, versus the other ones are marijuana businesses, they need a license. I would suggest if you're growing a lot of marijuana that in your business, at a minimum, you folks would want to keep that enclosed, an enclosed facility, which we have a definition for. I would not, so I wouldn't suggest touching what's going on page 7, number 1. If there's a debate, I think it's on page 4.
Right. So thumbs up, thumbs down, and
Well, it'll be good because I'm going to come back with something and I need, we're going to need to vote on this. So do people want to keep it, basically, do we want to allow personal recreational and medical use grows? Do we want to allow people to do that outside for their own personal use, either as a caregiver or for adult use?
Are we allowed to prohibit that? There was a question.
Well,
Yeah,
we're certainly going to look into it, but I think we are. I mean, we're not allowed to say you can't grow,
Right.
but we can say you have to grow inside a structure.
Yeah. I'd agree with that. I think that's exactly what the language
Okay.
says. But again,
Maybe we shouldn't say prohibited, but discouraged? Is that
I mean,
what the
I
question
think we can decide what we're generally in favor of now, and then come back with,
Yeah, and I'm not suggesting I'm going to have the language for you right now. I just need to know generally, do you guys want to allow outdoor grows for personal use, whether it's adult use or medical?
so Counselor Patton got a question.
Not a
comment, sorry.
question. I was just saying, I'm in favor of indoor grow, period. And even if the state ordinance says whatever, doesn't it still fall under odor ordinances for outdoor grows and such? But it's still restrictive regardless of whether or not we say yay or nay door to outdoor grows.
Agreed. If we're going to allow it outside, it doesn't necessarily change the odor provision, so.
And I don't think it should be, but I
The
do
other,
think.
the other thing to consider is if you're going to allow it outside, do you want, what kind of security, what kind of fencing, what kind of other requirements are you going to require?
I mean, I'm in favor of not letting it grow outdoors, just period.
So do we want to just do thumbs
How about-
up?
yes, why don't you-
Thumbs up on who is in favor
Well,
of,
I'd like to see that language prepared anyway, regardless, so that we
Okay.
have it, so.
What I'd suggest, if you give us some guidance,
can I,
give us some guidance so that we can put something together to put in front of you. Then if you want to amend it, you can move to amend it. And we'd be glad to draft up amendments for you.
I mean, if thumbs up, thumbs down isn't going to work for everybody tonight, I mean, I just feel like it is a waste of staff's time if if 5 or 6 of us here are not in favor of outdoor grows, and the rest of us are, it's going to come to the council and we're not going to vote in favor of it, right? I mean, that feels like a waste of staff time to me.
It doesn't, you may be correct, but it does not preclude people from moving an amendment at that point. So if you decide you don't want to allow outside, and Jim really thinks it's an important issue, he can introduce an amendment to that effect, and you can vote on it. That way, he's on record to his constituents of what his position was.
Yes. So,
So
we're back to thumbs up, thumbs down.
if you want to require it all to be grown inside, put your thumb up.
I'm sorry, say that again, please.
So growing only inside.
Correct. No
Personal use
outside.
growing inside.
Inside has to be inside a structure.
Just for clarification purposes, if you're in favor of growing outside, thumbs up.
Vital is vital.
It's a short growing season anyway.
And again, there's nothing that says you can't change your mind.
Right. And then next was,
So I'm not necessarily changing anything there. I absolutely will, the concern that was raised by DJ, I will make sure that we are on safe territory with respect to that. The other issue, it wasn't necessarily a thumbs up or thumbs down to me, but it keeps on coming up, is the 500 feet separation. Right now, again, they have to be separate. Are we okay with that, or do we want to allow multiple businesses? It's not that you can't have multiple businesses in one location. For example, like a strip mall, you know, you could have, theoretically, I suppose you could have 3 marijuana businesses in there as long as they met that locational criteria of being, you know, the third one is 500 feet away. So one's all the way on one side of the property and the 2 are on the other side of the property. The issue becomes more of in a downtown type environment where you have smaller lots and the businesses are closer to each other. The caregivers are probably right in that there may be some time of flux here. You know, maybe the market's gonna drive this, how it goes in the future. Everybody's gonna abandon medical. I don't know. But if I guess I'm of two minds. If you leave it, I don't know how many establishments we're gonna have, right? I mean, I don't know if we're gonna have a flood of establishments. There's still a lot of interest. If we're concerned about having a lot of businesses in town coming in, then you folks probably want to be more restrictive. Or you can relax it, and if things go crazy, we can come back and revisit it and you know, put the brakes on it again.
I'm comfortable with it the way that it is.
One that I clearly didn't have a thumbs up on, I guess, and maybe I need to look at the state law, was number 11 on page 9 with respect to the deliveries. We heard that there isn't much of a difference between the assistant and the caregiver. Hearing that, I don't necessarily have a problem with changing that, so there isn't necessarily a restriction with respect to who's making the deliveries. It's not something I've talked to the chief about to see if he has any concerns about that, so.
He doesn't.
He doesn't? Okay.
He shook his head.
He's shaking his head right there.
So, if the council's comfortable with that, I can make that distinction that it doesn't really matter as long as they are registered to deliver the medical marijuana. That way there isn't a distinction as to who those people are.
I mean, if they're handling the product in the same way, it doesn't make a lot of sense to me why we would differentiate. I think as long as we're able to track it in the same way, which gets at your point of knowing who's making the deliveries, which it sounds like we can because they have cards just like.
Yeah, and that's something, I mean, we'll have to think about how we do that with the license application that goes with this. I mean, this will probably be a pretty extensive license application to begin with because we're asking for a lot of information. So that would include, you know, who do they have for employees if that's truly a concern.
David,
Yeah.
easy thing is to require the employees
Copies of the cards.
to get their own license and register with us. So that we don't have to have, I mean, the concern obviously is once you get that card, you get fired the next day, but you've got a card that you can drive around with, that you can show to the police officers that gets you off the hook if you're driving around with marijuana in your car. I think maybe the solution is for both the caregiver and the caregiver assistant to register with the city to get a license from the city.
Counselor Petfield?
What do you think, David?
I think I need to give that some thought because right now we are licensing the business, making sure that they meet all the locational criteria. They're showing us for, at least for a caregiver operation, they have to demonstrate that they are a licensed caregiver. But when it comes to adult use, I'm not sure what they're gonna have to demonstrate.
But this is just right now for
medical purposes.
medical purposes.
So I'd probably want to actually ask some of the caregivers if they have a number of employees, are we going to ask each one of those employees then to license with the city?
I mean, the concern I have is if you have the business just report it, who's going to be policing the business to make sure that, you know, with turnover in employees every few months or every few weeks, that they're going to have, that they have reported?
Understood, and that's
Because
why,
if they, you know, I mean, it just gets to be a horrible enforcement issue.
and that's in part why we had it written the way we did, because it was the caregiver.
But the caregiver assistant is licensed through the state, so I would, if he no longer works for that business, they're still licensed through the state. So I think if they provide us with
If
the
they're licensed
caregivers.
through the state and they're not working for a caregiver and they're delivering marijuana, they're illegal. But they've got the card that's
Right,
going to
where
make
they
you
got the
happy.
card, but I mean, if they give us that license when they're employed, I mean,
But whether they're an assistant or whether they're the caregiver, if they're no longer working, it's the same situation.
Right.
So there's no differentiation. Do you know?
Right, and I think we have to have, like, if they're gonna have 8 pound, I mean, the reality is for them to get pulled over, I mean, if they have 8 pounds of marijuana in the car, that would really, would be what would kind of get our attention. But if they have a small baggie, it's not as if we're going to be arresting or summoning somebody for it because they can have possession of
But
it.
if they have a small bag in the front seat, you stop them, and they've got 8 pounds in the trunk, and they show your card, you no longer have reasonable cause.
Well, that's where, we'd have to rely on the businesses if they're no longer working there. But I think my take on it is, if we're asking them to also, are we saying that they have to pay the $1,000, the $500 fee?
No, not necessarily, no.
That
I'm not
might-
suggesting
that,
this
to me, it seems
be
a
the
little
same
extreme.
level.
Good thing we have these workshops so we can talk
Counselor
about all this.
Pettengill, what do you think?
My question was, how do we, is there a database that staff or the police has access to if somebody's pulled over late at night to be able to check the validity of that? And I
No.
can see you shaking your head
No,
with it.
we do not have access to that. They don't give
Because
us.
I agree having an idea who's on the streets doing these deliveries is a good idea, but it's the enforcement piece that I imagine is a nightmare and all over the place. I work in an industry that's highly regulated, and you have to notify the state through the licensing if key personnel changes. It doesn't happen all the time, so to put the faith into businesses, there are some, and there's a couple in the audience that I know that would probably do that, but there's a handful out there that wouldn't. So while it's a good idea, I worry about the enforcement of that, procedure or policy.
I guess I just wonder how it would be any different than what the policy currently is.
Agreed. I mean, that goes for the whole industry.
Right.
I mean, we only know what we know. So,
Why don't we leave it at this? Seems to me that there's some interest in allowing both, and let us at staff level do some discussions and see how we can make that work.
Right.
I believe that's all I had for direction, or what I was looking for direction. I don't know, administration said maybe we should make the fees the same as Auburn's. I'm not sure if that's something you guys want me to just look at and I can adjust them accordingly. So there's some consistency between the two communities.
Counselor Pettingill?
I'd advocate for going a little bit higher than Auburn, not going towards Portland. I think that would price it out and kill it. But I don't see any reason why Auburn is our benchmark. I think we can do better than.
At least as much as theirs.
I would say more. I mean, we're a better city than Auburn, so.
No question about it.
Counselor Ray?
I was going to advocate for less than Auburn, so
Because we're
you're
a better
welcome,
city than
Dave.
Lewiston. Yeah.
One of the reasons that we've often tried to stay in line with Auburn is to not create an economic incentive that advantages or disadvantages one city or the other, which certainly could happen. Probably not so much if they were close, but certainly if we were charging Portland's fees and Auburn was charging their fees, everybody go over there, or vice versa. That could either be good or bad, depending on your position on the whole issue.
I agree that keeping them at least somewhat in line with each other, whether that's a little bit less or a little bit more right on par, would be a good idea. Counselor?
The only other thing is, no one told me how much marijuana costs still, so I don't know if this, like, if you're upcharging a lot and then the fees are really low.
Well, as I recall, our police department purchased some.
Oh.
Remember what that cost?
Or we could ask the
Research.
number of people who are selling it.
For a small baggie, it's about $30, depending on what you're getting, but about $30 for a little small baggie of it.
Is that one?
Like a
use?
snack bag, not a sandwich bag, smaller bag.
I don't know.
Oh, those
You
little
wouldn't
s-
smoke
those
a whole
little
bag
snack
at
bags.
once. I mean,
I
unless you
personally
were
would not
really,
smoke any
were
of
like,
I
not
voted against
you,
this.
not you, what in particular, but a human probably would not do that, I would imagine.
It's a small sandwich bag. How long does that take for one of your patients to consume?
Anywhere from a week to a day.
Okay.
Right, depending on their use, so.
Okay.
And if you put it in the smoke in a pipe or you put it in
Cindy, better be quiet.
My husband has a lot to do.
Other questions? Council Marcotte?
Well, I'd be curious, seeing as how LD 335 was brought up, and I remember seeing this appear on the sales tax form that I fill out for my employer each month. And I think I remember inquiring at the time of the state, but if someone has more of an inside with the state, getting some sort of report on what kind of revenue's been generated from the various towns. I'm sure those statistics are readily available.
Yep.
I can,
It sounds like Alex has them, right, to,
Well, so I know that the projected revenue from that 12% for the first year is 56 million.
that's,
Based on information from, and that's for the whole state
Yeah.
now. But that's based on information from the Maine Cannabis Industry Association, which does their due diligence.
so I think that
Yeah, there-
MMA already has that breakout by municipality. So maybe you could ask Kate Duflo.
Well, I can certainly ask and find out. I will just point out that obviously there is no history in Maine at this point
Right.
because that 12% is only for adult use, and there is no adult use sales going on yet, although there may be some communities that are just starting up. So I can talk to Kate and see if she has any estimates. It's clearly going to depend on how many communities opt in. So, if Lewiston was the only community opting in this region, we would certainly have a much bigger revenue than if it's Lewiston and Auburn and everybody else around here. So I think right at the moment, it's going to be kind of hard to estimate, but I'll see if we can come up with some kind of number.
And it also comes down to who's honest and supplies that information and pays those taxes. There's plenty of businesses out there that don't collect sales tax, even though they should.
Well, and there's also, remember that this only applies to adult use, so in effect, it's an extra use on one element of the business, and if you qualify as medical, you may want to continue to get your medical because you're not paying that extra 12%.
And I would
Now, I'm not also going to suggest that anybody in this room would do it, but if you have a medical and a recreational operation together, things could get a little messy in terms of directing people to certain locations and urging them to get a medical card if it was cheaper. And again, I don't know what the pricing differential is going to be between medical and recreational. I expect that's going to work itself out over time.
I can forward the council. MMA posted a bunch of stuff from a workshop they had a couple of weeks ago. And on this PowerPoint, which came from the Office of Marijuana Policy, estimated adult use tax collections. So taking into consideration all the variables Ed just talked about, in 2020, they expect a total revenue of $4.4 million, 3.8 going to the general fund, $500,000 going to public health and safety, and $58,000 going to the local government fund, which I'm not sure what that is.
It's a revenue sharing fund.
The point being, which blows me away on here, is, so 2020 is 4.4 million. By 2023, they estimate 33.2 million, with 28 million going into the general fund and 438,000 going to the local government fund. So they are expecting the industry to pretty much explode here as far as tax collections in 4 years.
And that's been the argument against this, giving the 12% back to municipalities, is that they're already getting it back in revenue sharing, which is unfair to the municipalities that opt in, because obviously they're taking the brunt of the work.
I'll have to think about that. So the 56 million that was referred to earlier is simply the gross amount of taxes that's anticipated to be received in 2019?
I'm not entirely sure. So this meeting the MCI meeting actually just happened last night. It was one of the attorneys that's on the executive board. He did say that he wasn't entirely sure about that number, but that is the number that he quoted us for, that the 12% would be. Now, he may have been wrong about that. That might have been the total.
That the gross revenue before providing the 12%. Right. Not 12% of a much higher number.
Right.
Okay.
So the public, yeah, is that okay? Okay. Are we good?
Yeah, we're good.
All right.
Thank you.
Thanks,
Can I
Dave.
just comment again for those here or anybody else who's watching at home, if they have other comments, feed them into Dave Hediger. Please. So that we can keep long lists of all of the issues and things we're unclear or confused about.
That's right. I am no means an expert.
So our last item is review of the draft rental registration ordinance. Don't go anywhere, Dave.
I was just thinking, I'm not
that's-
talking, am I? You know?
That's pretty much me.
I'm here for backup if necessary.
Okay, there is included in your packet a draft of the ordinance. This is pretty much my effort, along with circulating it through a bunch of staff members, to come up with an ordinance that would establish a rental registration program that lines up with what was recommended by the Ad hoc Committee on Rental Registration. And basically, it's, I think, pretty straightforward. It would require all multifamily buildings to be registered. Multifamilies are 3 rental units or more, so it would have to be a registration on each building. We would have to be given information about the legal owner of the property, the business operator, who's the person basically who has the authority to make business decisions about the property, the emergency contact, which is one of the things we really need. That's who do we call when something happens at 2 o'clock in the morning? And then the management company that's in charge of the building, because frequently they're the people that we get in touch with about smaller issues during the regular day, such as trash or weed issues, those kinds of things. Everybody would have to, each building would have to be registered. Registrations would have to be done by March of each year. And on page 3 of the ordinance, section 18-6, talks about the kind of information that we're trying to get from them, which obviously includes what I was mentioning before, the names and information on the owners, business operator, the property manager, the emergency contract, street address, including map and lot number, and the reason we want all of this, and real estate tax identification number. In the real world, our addresses are sometimes different than the building owner's addresses are, particularly with some of the buildings in downtown that are on corners. They may be addressing, their folks may be using a mailing address that's on one street. We're using a legal address that's on another street. So we just want to make sure we know what building is being registered. Information on the number and types of dwelling units in the building, year the building was constructed, and this last one is this documentation for whether the building is lead-free or lead-safe. That's related to our interest in trying to establish a lead registry. And probably there, what we would ask for is if they claim the building was, if the building was built after a certain date, we'd probably pretty much assume it was lead-safe. If it was built before that date, we may ask them to voluntarily, if they want to register the building, to provide us with the most recent certification or survey that was done of the building to establish its lead status. So we could include both that it was lead-safe and as of a certain time. And then whether the building's monitored or supervised by a fire alarm or sprinkler system, because that kicks in some other requirements on the part of the fire department to do inspections and to be aware of what's going on there. Some conditions about reporting changes to us if they happen during the year, so that we can keep the information updated. Councilor Marcotte made a few comments and suggestions on this ordinance. Many of them are relatively minor formatting issues. The one substantive recommendation he made is right on in 18.6, right after the list of A through H. Starts, as a condition of registration, all owners must allow on-site inspections of their buildings by the city. Councilor Marcotte suggested that as a condition of registration be eliminated. That language was in there so that if they didn't allow an inspection, we could pull their registration, which would then put them in violation of the ordinance for having an unregistered building and give us the ability to take some enforcement action. So that would be a substantive change. I don't know if that was Counselor Marcotte's intent in making that recommendation, but
No. When I read it, I read into it that as a condition of registration, all owners must allow on-site inspections. So if they decide not to register, then they do not have to permit on-site registrations.
I can address that by rewording it.
Okay.
And just basically saying something along the lines, all owners must allow on-site inspection, so on and so forth. Failure to allow an on-site inspection will result in the building's registration being revoked.
A lot better.
Yeah, great, okay.
That works.
And pretty much, there is some language in here about if you are unregistered, you're obviously in violation. And if you are unregistered, you would not be eligible for certain programs that the city offers. You know, for example, lead grants, CDBG grants, those kinds of things. So there is a little bit of a benefit that you become eligible for those things. We had also talked about, I didn't put it in here because we haven't really started it yet, but I think at the point where we get into electronic meter reading, where we're reading our water meters from a distance, we had talked at the committee about providing a priority to people who are registered, who want to go into that program, and even to allow them to pre-purchase their meter in effect and get a credit in their bill over time, because that would allow them, one of the big complaints we hear from landlords is if they have a water problem in the building, they often don't know about it until after they get their water bill, where if they were notified sooner, they could take action sooner to fix the toilet or the leaking faucet. And with the new electronic system, they will be able to inquire regularly on their water bill status and see what usage is so that they can more quickly respond to it. Appeals from all the ordinance go to the Zoning Board of Appeals. And then I did note at the bottom there, we would establish a fine schedule. That would again be done in our master policy. Failure to register would be $50 penalty for the first month, would go to $100 per month for the next months, up to 6 months, and $200 per month for any additional time beyond that. So there's a kind of an escalating penalty to give people a reason to try to get registered. And then for other violations that could be incurred, there'd be a $100 fine.
So does the water meter thing show up in here?
The water stuff doesn't show up in here because we haven't really kicked that program off yet.
Okay. So is that just something we'll put out to folks, we'll offer to folks? when
Yeah,
we-
at the point where that program goes online, we will probably come to you with something that officially authorizes us to do that.
Okay. Counselor Lyson?
Yeah, Amy, have you looked at this draft? And,
So we're going to go to public comment.
great.
Once.
I just wanted that response,
Yeah.
if she had a chance.
Yeah, I have been I've shared this with everybody on the committee.
Counselor Ray?
For other violations under the potential fee schedule, what would an example of that be?
They don't update the information, so we go to try to contact an emergency contact, and they have not updated the information as they're required to do. That would be a violation.
You don't know how that's different from not having a current registration.
They would be registered. In other words, they would register, if I registered tomorrow and I said, Dennis was my property manager, my emergency contact, I've then got a responsibility to let the city know, I think within 30 days if there's a change. And if I don't do that and we try to contact Dennis 6 months later and he says, what are you calling me for? I don't do that anymore, that would be a violation.
They're registered,
You're still registered.
Information is
You just- your
changed.
information is wrong.
$50 talks about it. Would it be appropriate to say the $50 per month fee is if a registration lapses and it's not registered? I think that's what you're
Yeah,
pointing
that's
towards.
that is for, if you don't register the building at all, or you don't re-register the building, that's what that applies to.
Okay, when I read that clause, fails to have a current registration, the situation you just applied.
Yeah, it will be detailed more clearly in the policy
Terrific.
that
Thank
goes
you.
with it.
Other questions on the council? to the public. You're good? Okay. Did she answer everything you want to answer? Okay. Good, this looks great. I'm excited. We're doing it, finally.
Miss that?
I said, this looks great. I'm excited. We're doing it finally. Sorry, was I not talking into my microphone?
Yes. Well, we'll put this on for first reading on Tuesday.
Okay. Okay. Great. We are done. Thank you, everyone, for coming.